Have you ever wondered if you might, like, entirely by accident, secretly hold a second citizenship?
Oh, wow.
Yeah, like it's just sitting there completely unknown to you, waiting to be claimed. It sounds like, I don't know, the premise of some espionage thriller.
Right, or a late night internet rabbit hole you fall down.
Exactly.
Yeah,
But for a really surprising number of people right now, it is actually a legal reality.
it really is.
So today we're taking a deep dive into this unprecedented opportunity that has just opened up in Canadian immigration law.
Yeah, it's a huge shift.
It is. We have this highly detailed legal breakdown provided by a Toronto-based lawyer, John Richardson, JD, and he unpacks Canada's Bill C-3.
Which is a massive piece of legislation.
Massive. It officially took effect on December 15th, 2025, and it's basically this amendment to the Citizenship Act that radically alters the landscape of Canadian citizenship by descent.
Radically is the right word for it, yeah.
So our mission today is to sort of decode the legal mechanics of this bill, look at how this law effectively reaches back in time, which is wild, and figure out exactly what it takes to pass this citizenship down to the next generation.
Right, to actually pass it on.
Yeah. So, okay, let's unpack this.
Sure.
Because usually, when you want to understand a law, you assume you could just like open up the statute book, read the current text, and boom, you instantly know what the rules are.
Right, you'd think so.
But Richardson makes it very clear right at the beginning of his post that if you try to do that with the Canada Citizenship Act, you are going to walk away completely lost.
Oh, completely. I mean, lost is putting it mildly. It is notoriously difficult to parse.
Yeah.
Yeah. And the confusion stems not just from dense legal terminology, which is bad enough, but from how the legislation itself is physically constructed over time.
Like how it's actually put together.
Exactly.
Yeah.
When a government passes a new citizenship law, they rarely start with a blank piece of paper. Because rewriting a law from scratch risks invalidating decades of settled case law and, judicial precedent.
Oh, that makes sense. You don't want to just throw all that out.
Right, you can't. So instead, Parliament amends, they patch, they cross things out, add clauses, introduce these highly complex numbering systems.
So it's just layers upon layers.
It really is. Section 3 of the Citizenship Act, which actually dictates who is a Canadian citizen, is essentially a repository of repealed laws and just a chaotic web of new amendments stacked precariously on top of each other.
Honestly, reading through the excerpts provided in our source material, it felt a bit like walking through a house that has had like 50 different renovations over the course of a century.
That's a great way to look at it.
Right, like you open a door expecting a bathroom and bam, it's a brick wall.
Yep.
Or there's a staircase leading straight to the ceiling, which represents some, repealed section from 1977.
Yeah, exactly.
You just can't possibly understand the current floor plan without knowing exactly what used to be there, when it was built, and why they decided to tear down that one specific wall in, 2009.
I love that. The house renovation analogy works on a basic level, but let's take it a step further to truly capture the complexity here.
Okay, lay it on me.
Imagine those architectural blueprints were also written in a mix of contemporary and archaic languages.
Oh, wow.
And certain structural foundations were entirely replaced while they left the upper floors totally intact.
That sounds like a nightmare.
It is. Richardson actually quotes the great Canadian lawyer J.J. Robinette in his post, who stated that a lawyer is, in essence, a practical historian.
A practical historian. I really like that.
It's so accurate. The Canada Citizenship Act is the ultimate manifestation of that idea. You literally cannot make sense of the current document without understanding the historical iterations of the law.
Because it's all tied to the past.
Right. This confusing historical context, the century-long renovation project, is exactly why so many people fundamentally misunderstand their citizenship status today.
They're just looking at the wrong blueprint.
Exactly. They look at the current rules, they apply them to their birth in, say, 1980, and they arrive at the totally wrong conclusion because they aren't factoring in the historical patchwork that was active at that specific moment in time.
Wow. Which, I guess, brings us to the actual renovations that Bill C-3 just made to the statute.
Right.
And I found this part really hard to believe at first because laws usually look forward, right? Not backward.
Usually, yes.
But the new law didn't just add a room for the future, it actively went back in time and changed the past.
It did.
According to Section 3.1 of the Act, if you were born outside of Canada prior to December 15, 2025, to a Canadian citizen parent, you are a Canadian citizen.
Yep.
Not that you can become one, but you are one from the exact moment of your birth. even if the old iterations of the law specifically denied you citizenship when you were born.
That's the kicker.
Wait, so how does that actually work mechanically? Does Parliament just pass a law that forces the legal system to pretend the old rules never existed for these specific people?
Basically, yeah. What's fascinating here is the sheer power and mechanism of retroactive legislation.
It's like actual legal time travel.
Yes, Parliament is effectively rewriting the historical timeline. Bill C-3 acts as this massive legal override switch.
Okay.
It looks at all those previous historical laws that might have stripped citizenship from a parent, maybe due to archaic rules about marrying a non-citizen,
Right.
or denied it to a child born abroad under previous generational limits. And it instructs the courts and the bureaucracy to treat those old restrictions as totally void for this group.
That is a staggering amount of legal power.
It really is. If you were born before December 15, 2025, and you had a Canadian parent, this law reaches back to your birth date and recognizes your citizenship retroactively, like the restrictions had never even applied to you.
It's as if the government went into their archives, pulled a file from 30 years ago that said denied, and just stamped approved on it, while the person was busy going about their life in Ohio or London, completely unaware.
That is the practical reality for thousands of people right now.
Incredible.
And the source text frames this in a rather elegant way, I think. It refers to this kind of citizenship as a family heirloom that can be passed from generation to generation.
A family heirloom.
Yeah, because of the way this retroactivity is structured, Bill C-3 might actually recognize your parent as a Canadian citizen first,
Oh, I see.
which in turn means you were born to a Canadian citizen prior to December 15th, 2025, making you a citizen as well. It creates this cascading effect through entire family trees.
That cascading effect is just incredible to think about.
It's massive.
And, there is an implication here that I think we really need to highlight for you listening. Suddenly discovering you are a citizen of a new country sounds great, but it often comes with a catch, usually in the form of the tax authority.
Right, the dreaded tax man.
Yeah. But this heirloom is uniquely safe in that regard, isn't it? Because unlike the United States, which taxes its citizens regardless of where they live on the globe.
Which is very unique to the U.S.
Right. Canada bases its taxation primarily on residency, not citizenship.
Exactly.
So inheriting this heirloom doesn't automatically mean you suddenly owe decades of back taxes to the Canadian government just because you exist.
That is a crucial contextual distinction. The acquisition of Canadian citizenship by descent does not, in and of itself, trigger Canadian tax residency if you have literally never lived there.
Okay, good to know.
The rights are granted, but the burdensome obligations associated with residency remain dormant until you actually establish physical and economic ties to the country.
Phew. That's a relief.
Yeah, and the most critical detail here, one that Richardson really emphasizes for anyone listening who might fall into this retroactive category, is that there is absolutely no deadline to apply for your certificate of Canadian citizenship.
Wait, really? The heirloom doesn't expire?
Oh, nope, no expiration date.
You could have been born in, 1965, living your entire life under the assumption you had no legal ties to Canada, and suddenly, because of this December 2025 law, you could just submit your paperwork, claim your certificate, and your legal identity shifts.
Just like that.
And your children might be eligible too. This is basically an open-ended invitation.
It is an unprecedented opportunity, exactly as the text notes. But that magic wand of retroactivity has a strict, unyielding cutoff.
There's the catch.
Yeah. That December 15th, 2025 date acts as an ironclad dividing line in the legislation.
Right.
It separates the group receiving the unconditional family heirloom treatment from those who are subject to a much more rigorous, forward-looking set of requirements.
So if I am a second-generation child born abroad after 2025, how does the government stop this from becoming an endless chain of people holding passports who have never even seen a maple tree?
Well, that's exactly the issue they wanted to prevent.
Right. And here's where it gets really interesting, because for those born on or after that magical date, the government stops time traveling and starts setting some very strict boundaries.
Very strict.
Let's look at Section 3 of the Act. If a child is born outside of Canada on or after December 15, 2025, and their Canadian parent was also born outside of Canada, the rules change drastically.
They do. In that specific scenario, the Canadian parent must have accumulated at least 1,095 days of physical presence in Canada prior to the child's birth in order to successfully pass the citizenship down to that next generation.
So it's a hard requirement.
Yes, that is exactly 3 years of physical presence, and the timeline is strictly capped at the moment before the child is born.
Wow. I was trying to wrap my head around how to visualize this mechanism, and it's almost like a legal battery.
A battery.
Yeah, like the state requires a minimum kinetic charge of domestic residency, those 1,095 days, before it allows you to pass that sovereign protection outward to a foreign-born dependent.
Okay, I see where you're going with this.
Like, if you are a Canadian citizen born abroad, you are carrying this battery, but it is effectively at 0%.
Right.
You have to physically return to Canada, plug yourself into the domestic infrastructure, and recharge that battery for exactly 3 years. Only once you hit a 100% charge do you possess the legal kinetic energy required to pass the spark of citizenship to the next generation born outside the borders.
If we connect this to the bigger picture,
Yeah.
your concept of a legal kinetic charge perfectly captures the policy intent behind Section 3.3.
Oh, awesome.
Because you have to ask yourself, why would a sovereign state implement this 1,095-day requirement in the first place?
Right. Why make it so complicated?
It's fundamentally about the philosophy of citizenship. Without this rule, you could theoretically have a family line living in Australia or Germany for 6 generations, passing down a Canadian passport generation after generation, without a single member of that family ever stepping foot in Toronto, Vancouver, or Halifax.
Right. At a certain point, the concept of citizenship just kind of loses its meaning if there is no physical, cultural, or economic nexus to the actual landmass of the country issuing the passport.
Precisely. Citizenship is a bond of mutual obligation between an individual and a state.
Yeah.
By requiring those 1,095 days of physical presence for the second generation born abroad, the government is essentially demanding proof of a substantial connection.
Like, show us you care.
Exactly. They are saying, we are willing to extend the ultimate privilege of citizenship to your foreign-born children, but you, the parent, must first demonstrate that you have a tangible, lived connection to this society.
Right.
You have to prove you spent 3 years breathing Canadian air, engaging with Canadian institutions, and participating in the societal fabric before you can hand that passport down.
And John Richardson's post makes a huge point of underlining the word proof.
It does.
It says, quote, "Proof of the 1025 days of physical presence is crucial. You can't just cross your heart and promise the government you were there.
No, absolutely not.
You have to document it. But how do you actually prove that? 3 years of physical presence is a massive administrative hurdle.
It's a huge hurdle.
Does a 2-week vacation to Banff count toward the 1,095 days? Does a semester abroad in France break the streak? If you are an expat listening to this right now and planning a family, this means every flight back to Toronto for Christmas literally counts towards your child's future passport.
Yeah, the administrative burden is entirely on the applicant, and that is a critical point. A 2-week vacation technically counts as physical days present, but proving it decades after the fact is another matter entirely.
Yeah, how would you even do that?
Well, physical presence means exactly that. Feet on the ground, inside the borders of Canada. It is not about simply maintaining a mailing address or holding a Canadian bank account while you live in Dubai.
Okay, so no loopholes.
No, you have to track your entry and exit dates meticulously. Border crossing records, employment histories, housing leases, physical utility bills, these are the types of evidence the government will scrutinize to ensure that the 1,095-day threshold is met down to the exact day.
That sounds like a forensic accounting nightmare for the average person.
It really can be.
But before we get too lost in the bureaucracy of keeping receipts, I want to bridge this to another group. Wait, what if the parent didn't have a Canadian battery to begin with, but earned one later?
Ah, okay.
Like, what about immigrants? The law doesn't treat every Canadian living abroad the same way, does it?
No, it does not. The 1,095-day rule under Section 3 applies specifically to a child born outside of Canada, to a Canadian parent who was also born outside of Canada.
Right.
The legislation carves out distinct and very purposeful exceptions that fundamentally change the math for certain groups of people.
So if you are a Canadian who was actually born in Canada and you move abroad and have a kid, you don't need to worry about the 1,095-day rule at all.
Okay.
Your battery is basically permanently charged by virtue of your birth on Canadian soil.
Yeah.
You pass it on automatically.
Yep, you're good to go.
But the source material also highlights a few other very specific exceptions, and the naturalized citizen is the one that really stands out.
It is an interesting one.
According to the text, if you are an immigrant to Canada, you go through the rigorous process to become a naturalized Canadian citizen, and then you move abroad and have a child. You are not subject to the 1,095-day rule to pass on your citizenship.
Right.
Your child is just automatically Canadian.
Yes.
But doesn't this create a massive paradox? Doesn't this mean a naturalized citizen actually has a smoother, easier path to passing on citizenship to a child born abroad than someone who is born abroad themselves by descent?
It definitely looks that way.
Because the naturalized parent doesn't have to forensically prove 1,095 days prior to the birth.
It absolutely seems like a paradox on the surface. I mean, imagine two Canadian citizens standing side by side in a foreign hospital holding their newborn babies.
Right.
One has to submit years of utility bills and border crossing records to prove residency, while the other doesn't have to prove anything beyond their own citizenship certificate.
Which feels totally unfair.
But when you examine the underlying logic of the immigration system, the paradox dissolves. The naturalized citizen is exempt from the 1,095-day rule because the entire legal process of naturalization already requires profound and documented physical presence in Canada.
Oh, right. So the government has already done the forensic accounting on them. They've already paid their dues, so to speak.
That is the core of the exception. To become a naturalized Canadian citizen, an immigrant must first secure permanent residency, and then they must physically reside in Canada for a specific statutory period, which is actually heavily scrutinized and often exceeds the 1,095-day benchmark before they can even submit an application for citizenship.
Oh, wow. I didn't realize that.
Yeah, the government already possesses a highly verified, documented record of their physical presence. They have taken the oath. They have definitively proven their ties to the country to the satisfaction of the state.
So they don't need to do it twice.
Exactly. Therefore, when that naturalized citizen goes abroad and has a child, the government does not require them to prove their physical presence a second time. The naturalization certificate itself serves as irrevocable proof that their legal battery was fully charged.
That is a really elegant way for the drafters to structure the law. It completely avoids double jeopardy on the bureaucracy for naturalized citizens.
It's very efficient. Yeah.
But it still leaves the burden of proof squarely on the shoulders of the citizens by descent.
It does.
What about the other exceptions? The text mentions adopted children and diplomats.
Right.
Do they fit into this same logic?
They operate on different legal principles entirely. Let's look at diplomats first. This exception is a standard element of international law, rooted in the concepts of jurisdiction and sovereignty.
Okay.
Children of foreign diplomats who are born on Canadian soil are a strict exception to Canada's birthright citizenship rules.
Because you can't just force your citizenship onto the child of someone representing a foreign government. That feels like it would cause an international incident.
Precisely. A foreign diplomat is, legally speaking, operating under the jurisdiction of their home country, not Canada, due to diplomatic immunity.
Right.
To automatically grant Canadian citizenship to their newborn would be an infringement on that sovereignty. So mere birth on Canadian soil does not confer citizenship in that highly specific scenario.
Makes sense. And adopted children. How does a child adopted from abroad by a Canadian parent fit into this matrix?
The law explicitly notes that children adopted outside of Canada by Canadian citizens do not automatically become citizens at birth.
Oh.
The legal mechanism is different. Instead, they are naturalized by a direct grant of citizenship from the government.
Gotcha.
However, once they receive that direct grant, they are generally treated similarly to children born outside of Canada to a Canadian parent when it comes to passing that citizenship on to the next generation.
Okay, I see. So what does this all mean? If we distill everything we've unpacked today from John Richardson's legal analysis of Bill C-3, we are fundamentally looking at two massive buckets of people whose lives are impacted by this legislation.
We are.
Right.
Bucket number one is the retroactive group. If you were born outside of Canada prior to December 15th, 2025, to a Canadian parent, Parliament has reached back in time and handed you a retroactive family heirloom.
Which is amazing.
You are a citizen by operation of law. You simply need to claim your certificate, and crucially, there is no deadline to do so.
And bucket number two is the futuristic group, the post-December 14th, 2025 reality.
Yes.
If you are a second-generation child born abroad after that date, your parent carries the full burden of proving they recharged their Canadian battery for at least 1,095 days before you were born.
The full burden, yes.
So, The immediate actionable takeaway for you listening right now is to go interrogate your family tree.
Definitely.
Talk to your parents, dig into the history of your grandparents, find out exactly where they were born, when they lived there, what their legal status was, because this amendment might have just rewritten your legal identity without you even knowing it.
And equally important, if you are an expat Canadian who falls into that second bucket and you are planning to have children abroad in the future, you need to start tracking your physical days in Canada with meticulous precision.
Every single day counts.
As the text stresses, proving that physical presence rests entirely on your shoulders and memories fade quickly.
Which actually leads me to a really provocative thought to end on today. We've established that for that first bucket, the pre-2025 group, this citizenship is a family heirloom with absolutely no deadline to apply.
Right, no deadline at all.
Now, I want you to imagine it is the year 2080.
Okay, 2080.
You have a grandchild living in Berlin or Tokyo. They discover a recording of this deep dive in some digital archive, or they find an old diary in an attic, and they realize their grandfather, you, was a Canadian citizen.
Okay.
They want to claim their heirloom, but they fall into the second bucket. They need to legally prove to the Canadian government that you, their grandfather, spent exactly 1,095 days in Canada back in the 2020s before their parent was born.
Oh, wow.
Right. Think about the sheer forensic nightmare waiting for that person 50 or 80 years from now. Will future generations have to somehow dig up decade-old digital grocery receipts from obsolete apps, lease agreements from defunct platforms, or elementary school transcripts just to prove a strict residency requirement from half a century ago?
That is wild to think about.
It really leaves you pondering how the concept of proof will survive the relentless test of time.
It raises a profound question about digital legacy, bureaucratic memory, and just the fragility of evidence. Because while the law itself time travels effortlessly through the stroke of a legislative pen, the evidence we need to satisfy that law remains stubbornly tied to the fading records of the present.
It really does. So the next time you're cleaning out the attic or scrolling through an old folder of digital documents, don't just delete those old utility bills or report cards. You might just be looking at the spark that charges the battery for a hidden citizenship, waiting patiently in the dark for a future generation to discover.